Welcome to Southwest Florida Real Estate Update, hosted by area realtor Jim York and York Real Estate Group of Downing Fry Realty. Our show will bring you the most up-to-date information about the local real estate market, featuring leading experts in the real estate field.
Good afternoon and welcome to the Southwest Florida Real Estate Update. I'm Michael York with the York Real Estate Group, and I'm joined today by our host Jim York and his guest Don Ross of Ross Title and Escrow.
Thank you for the introduction, Michael. Well, Don, our monthly report here, updated. For our viewers that haven't heard of you or seen the show, could you just give us a little update about yourself?
Well, I'm Don Ross. I'm an attorney here in Naples. I've been here since '85. I'm a member of a law firm, Ross, Lanier and Dyfick. I own my own title company, Ross Title and Escrow. I'm a shareholder in Downing Fry Realty, been their attorney for 25 years. And we're on 41, corner of 6th Avenue North and 41.
And just tell us a little bit about your team.
The team's been with me for a long time. Janet, my manager, has been with me for almost 30 years. And I have 3 members of her family have been with me a very long time. There's 8 of us all together. We have the newest to join is Janet's niece. She's 21. Much too young for Michael, by the way, your son, but very close-knit group. The chemistry is really good, a lot of experience. We handle a fair volume of closings and enjoy each other quite a lot.
Yeah, I know our clients absolutely love your office and the people there. So, Don, I'm really excited about today because, a year ago I think we did a show like this that we talked about the most common mistakes people make when they're purchasing a property in the South Florida area.
Sure.
So let's start off with, I think the first one we were going to talk about was timeline of events, because that's critical when you're purchasing a property.
Sure.
So could you start with that, please?
Well, the effective date always comes into play, and we have 2 contracts here that we tend to run into, but the one we get the most in Collier County is the Naples Board of Realtors contract. So determining the effective date is always an issue, and it's the last date the opposing party signs, or initials if the initials are dated. That's the effective date, and everything is tied to that. Your inspection period, your financing contingency, and everything else that might be a contingency in the contract. So knowing the effective date is step 1, and it's very important because it's different than the one we use for the Florida Bar and the Florida Association of Realtors contract. That has a totally different definition.
Yeah, and the other thing is additional deposits can be
oh, sure.
need to be made at a certain time also.
I'm asked, what's normal for that sort of situation, and is there a law on how much the deposit needs to be? And I always tell people there is no law on how much the deposit must be. With the NABOR contract, though, you really need some sort of deposit because the damages clause limits the seller to recover only the deposits made if the buyer defaults. So if there's nothing down, you don't have any remedy for the seller, and therefore you don't have a contract. And as to the minimum deposit, I always tell people, well, I can tell you customary, it's normally 10%.
Right.
But as the sales price goes up, it tends to go down a little more. And the reason is the real function of the deposit is to both compensate the seller if the buyer defaults. It's got to be more than 1,000 or 5,000. So, it should be enough to be worth going to court for and compensate the seller. But also, it has the psychological ramifications of showing the seller that the buyer can actually afford the property.
Right.
I mean, if you're putting $2 down, the seller's going to ask, don't you have any money? I mean, why are you wasting my time? So you want to balance those 2 considerations if you're a buyer. You want your seller to accept your offer, and part of that equation is, look, I'm putting this much down, I'm going to close in 2 weeks, I'm serious.
That's right.
It's cash.
Right. Then next part, when we do a contract and it's executed, usually is we do the inspection. So you have 15 days to do the inspection. So maybe you could elaborate on that. What are the pitfalls of that?
Oh gosh, there are a lot of pitfalls here. The inspection process is really an art. I mean, how you handle it having as part of your team a good inspector,
That's right.
somebody who has some knowledge of the contract, what's considered working condition, what's considered cosmetic, not getting the buyers excited when they don't need to be. But the timelines that we look at, the standard Naples Board of Realtors contract, it's not as is, just the standard one, they have 15 days from the effective date to do whatever inspections they want.
And if it goes beyond that?
Well, then theoretically you might have waived your inspection.
Right.
If it's a day late, time is not of the essence, and arguably you could try to say that this still should be addressed. The problem is you have to argue about it.
That's right.
And depending upon your deposit, you have to weigh the risks of losing your deposit against winning that argument in court. So I try to tell my clients, make believe time is of the essence.
That's right.
We don't want to go down that road. It's an unnecessary road to go down, but you have 15 days for your inspection, and then you have 5 days after that to make your request of the seller to either remediate things that are in defective condition or get a credit. And again, back to the psychology, if you're going to ask for things, I try to tell my buyers, well, what are the most important things?
Right.
The things that really make a difference. And you try to explain to them the significance of certain items, especially if you have northern buyers who aren't used to dealing with mold or radon or some of the other issues that you and I see every single day. So I prepare my clients. I point out to them that the cost to repair something cannot exceed its fair market value. So if the air conditioner is 10 years old and the inspector suggests it needs to be repaired, you don't get more than what the air conditioner would sell for if it were working properly.
Right.
Now, I'll prepare my buyer for that, but then I'll tell my buyer, but we can ask for a brand new one.
Exactly, right.
I mean, you might as well go for it. Why not? But if your buyer's expectation is,
we're going to get a new
low,
one, right? Or
if it's, we're getting a brand new one, and they don't know any better, and
That's
then they get somebody who argues against them, then they're upset and they're angry, and then the whole closing process is difficult and contentious. So you have, again, back 15 days to do your inspections. You might have somebody there the 15th day, doing a radon test or, checking the air conditioner or whatever. But then they have to type up their reports, and that takes a few days.
Right.
And then you have 5 days after that to make your requests. And if you're going to ask for a credit, there's a whole psychology to that too. And it varies a little bit depending upon the purchase price. If somebody's buying their first home and they've saved every nickel they have to buy that first home, everything's important to them.
That's right.
Every little thing, even if it's a $50 item, it's important to them. So you have to handle that a certain way. If you're representing somebody buying a $2 million home, you're representing a CEO of some company, they know how to evaluate the pros and cons of going for all or none or some of the inspection items. They know what plans they have to do with the house, and they're willing to make certain compromises if they get most of what they want. So, for the credit, I usually recommend that you have an estimate. You're not required, well, at some point you have to get an estimate anyways. You give them an estimate and you're asking a credit for that work. And psychologically, that shows the seller that this is a real repair item.
Right.
You didn't make the number up. It's not a general request that I see quite often for a $10,000 credit. It's always an even number, 5,000, 10,000, it's always an even number. If you show them the actual estimate, then the seller doesn't think that you're trying to renegotiate the price, you're not trying to get some more money out of the seller,
Right.
And that this is really broken, not working, and that you want it fixed. So it keeps the emotions down. A lot of this is just managing emotions.
Exactly. Well, Don, we're going to continue this discussion, but we're going to take a little short break,
Sure.
and we're going to be right back in 1 minute. Thank you.
Thinking of buying or selling a home in Naples, Bonita Springs, or Estero? Think of the most experienced realtors. The York Real Estate Group of Downing Fry Realty. Let's have a look at what the McLeans have to say about their experience working with the York Real Estate Group.
Jim York was our broker in acquiring our present home in Bonita Springs. His knowledge and integrity made the process go very smoothly.
It was a pleasure doing business with Jim York. Everything was done in a superbly professional manner.
Welcome back. Don, how long does the seller have to respond after that 5 days that the buyer had to present it to them?
Okay, well, so once the buyer asks for their credit or their remediation, the seller has 10 days to respond. And what frequently happens is the second deposit is due right in the middle of that time period.
Right.
And the buyer doesn't want to put their money down unless they get a response from the seller. So I have to tell my buyer, well, then you might lose your first deposit because you'll be in breach of the contract if you don't put your second deposit down. But to point blank answer your question, they have 10 days to respond, yes or no. If the seller says no to something that's a legitimate item that should be in working condition, the buyer then has 5 days to cancel and get their money back.
Okay.
So
it can be 15, 5, 10, and 5.
Yeah, it's
to the end, right?
15 days to do your inspections, 5 days to present your request, 10 days to respond, 5 days to cancel.
Okay. Okay, and then, well, maybe we just talk about that some inspection reports are maybe 30 or 40 pages long, and some are up to 150 pages long, which can get a little confusing for everyone. So they really need to understand the contract.
They're exhausting. I mean, the last one that was of that length was 122 pages that I had, $4 million house, and they did it 3 times. Once during the walkthrough to see whether the property has been properly maintained, because that's one of the requirements of the contract. The seller has to maintain the property. So you're comparing 122 pages with another 122 pages 3 months later to see if there are differences. And just for me, I mean, that means I have to block out half a day and please don't call me and keep the door locked. I mean, to be able to focus on all those little details. So that goes back to my comment about having a good inspector on your team.
Yeah, we do.
I mean, you don't want somebody who's going to stir up fear. You want them to protect your client.
Right.
You want them to be good, but your clients need to know what they're entitled to, what they're not, and the inspector needs to know that too.
Exactly, right. Some of them don't. But next thing in the contract would be mortgage contingencies. So let's talk about that, because that's always
it's a
interesting
big
topic.
Yeah, it's misunderstood. Again, this is the NABOR contract, and I think it's paragraph 4. Yes, paragraph 4. The NABOR contract and the FARBAR contract are radically different in this paragraph. But basically, on this NABOR contract, the buyer has 45 days. That's the default language. You can put a different time period to waive the financing contingency and keep the deal alive. If the buyer does not waive the financing contingency, the seller has the right to terminate the contract. The buyer has the right to terminate the contract. If the buyer gets a letter of adverse determination from their lender that indicates that either the buyer isn't qualified financially, they have insufficient funds to close, excessive debt load, something specific about that buyer, or the property doesn't qualify. You have too many investor owners in a condominium, the reserves are too low, something of that sort, or it doesn't appraise. So the buyer needs something indicating that they didn't qualify. And what I always look for is whether or not the buyer made a good faith effort to get the loan. Did they apply within the 5 days called for in the contingency clause? Did they supply everything the lender asked them to supply? Because you kind of smell it after a while if they don't seem too excited anymore. And going back to our earlier point, how much is the deposit? I mean, if the deposit is $5,000, I'll be telling my seller, it's not worth hiring a lawyer who will cost $5,000 to go sue for $5,000. So you want a big enough deposit where the buyer's taking this contract seriously and the seller will be compensated and can actually, it's worthwhile to hire a lawyer to go after it. But here, if they waive the financing contingency and then there's a problem with the loan later on, the buyer needs to have other funds to close. I mean, they can't wiggle out at that point. They can get an additional 10 days if it's something relating to the bank's inability to get out their closing documents. Under the new law that was enacted effective last October, if the lender is unable to give them a closing disclosure within 3 days of closing, or some other thing goes wrong with the lender, it's automatically extended up to 10 days. But that's only if you waive the financing contingency. And again, I tell my buyers, if you waive, you either have backup money or you really believe your bank, because if you're wrong, you can lose your deposit.
Right.
You risk losing the deal or losing your deposit. So you have to have faith in your lender. And I get a lot of agents who, they want to advise their clients on this, and I tell them, you got to let the client make the decision, because you don't know what the client makes, you don't know what they have in the bank, you don't know what went into that loan application.
Right.
And it's really a business decision. Do I waive it or not? What's their risk tolerance? And if they have backup money, well, then they're fine.
Okay. Well, Don, we're going to take another little short break here, and we're going to be right back in 1 minute. Thank you.
Thinking of buying or selling a home in Naples, Marco, Bonita, or Estero, Florida? Think of the most experienced York Real Estate Group associated with the #1 brokerage in Naples, Downing Fry Realty, which produced $1.9 billion in sales in 2014, controlling 43% of all transactions in Naples. Jim, Michael, and Morgan York make up the York Real Estate Group of Downing Fry Realty. With over $250 million in sales transactions, they can offer you the expertise and trust you want and need in a realtor. Call them today at 239-273-6727 or visit their website, www.naplesyorkrealestate.com.
Welcome back. Don, the next thing would be is when a buyer buys something and the seller has to fill out some forms, they're obligated, not really obligated, but they're disclosures would be what's wrong with the house would be a disclosure, and the other one would be their fees if they live in a community and that. So why don't we touch about the disclosures of the home?
Well, disclosures are greatly misunderstood, and with a simple analysis of human behavior and psychology, I understand why the sellers would be, they're not going to put a whole lot of effort and go disclosing too much, or I get a lot of questions from realtors on, do we have to disclose something that was already fixed? Things like that. So the root of the disclosures is an old case from '85 that changed the law from buyer beware, caveat emptor, to the seller actually having a legal obligation to disclose latent material defects. And latent material defects are something hidden that would affect the value of the property and is defective. And the case involved Johnson v. Davis was a $300,000 house with the roof was shot, and the seller didn't tell him it was going to cost $20,000–$30,000 to fix the roof. So they said that's big. The Florida Supreme Court at that point said the sellers now have a duty to disclose. So the legal duty is to disclose that. Then you as a realtor, you're with Downing Fry. We have, and the Naples Board of Realtors has a disclosure form that all the lawyers and the realtors work on to put together. It goes beyond the legal requirement to a lot of practical things that pop up after closings. And in their judgment, and I agree with it, they added all these things, even though they're not big enough to affect the value of the house. It could be the ice maker was broken and things of that sort, relatively small financial things. They decided to add those items to the seller's disclosure because these types of things were recurrent problems with buyers. Buyers would be unhappy after the closing. They spend $1 million, they move into their home, and they find out that all these nickel and dime things are broken.
That's right.
I mean, they get upset. They feel like they've been misled, lied to, sin of omission, however you want to characterize it. And at that point, these wealthy people would be calling Jim York, they'd be calling your broker, they'd be calling me, and they'd call and call and call and call and call, and it's just taking up a lot of your time. And in some cases, they go after the seller. They'd go after the seller. And so the consensus was with the Naples Board of Realtors, let's have a comprehensive seller's disclosure. to avoid all these headaches so that the buyers don't get the feeling that they were misled or taken advantage of, and just disclose everything. Now, you've got the situation where something's been fixed. Do I have to disclose that? Well, the answer is no, but should you is probably a better question.
Right.
And in my experience, and I've seen every lawsuit that's come along in my 25 years as the attorney for Downing Fry, I can guarantee that the best thing to do is disclose things that happened before. And if you have invoices on what was done,
That's right.
you give it to them.
Right.
That way, you know, Jim York isn't saying the plumbing was fixed.
Right.
You just say, here's the invoice and what repairs were made to the plumbing.
Right.
The classic cases, and I know I've touched on this before, termites and mold. If it's something that can recur,
That's key.
you're out of your mind not to disclose it,
Right.
that you had some work done. Because they're going to find out later on, and it is something that could reoccur, and if it does reoccur, they're going to tie it to your prior remediation,
Right.
your prior repairs for the termites or the mold. I mean, mold keeps coming back. I mean, we live next to the Everglades. It's a semi-tropical climate. So you better disclose it. We've had litigation over this. We've had $80,000 settlements on termites. We could have avoided that if the seller simply disclosed to the buyer that, hey, we have termites in the shed, but we're going to remove it. I mean, that's simple. I mean, that's an actual case. And plus it promotes honesty.
That's right. Credibility.
You know, you're
right.
building, you've got to manage the emotions of the
Right.
transaction, and if they're going to trust you a lot more, the buyers will, if you just, here's the whole history, here's everything we did. And yet they're already excited, they're making an offer. And if the seller responds by saying, here's my seller's disclosure, and
Right.
you know, it's like the sellers that you run into who, here's the guy I used to cut the grass, here's the guy I used for my pool, you know, here's all the different services, here's my warranty papers.
Right.
Some people save that. It makes the buyers feel good, the whole thing goes smoother, and you don't get those threats after the closing. So that's the point of the disclosures. And as I said, they're misunderstood. If people would only know, and there's no way for them really to know, the sort of things that you and I see all the time after a closing.
Right.
Because people just don't like to be taken advantage of, and they feel that way if there's something broken and they weren't told about it.
That's true. That's true. Another thing comes up once in a while is surveys. So let's maybe touch base on that.
That's again human nature. The contract provides that if you have a survey, you're going to give a copy to the buyer. There's no financial penalty if you don't. Well, I get this a lot. The survey's somewhere. People may not even know whether they had a survey. I'll usually ask, did you have a mortgage? If you had a mortgage, there's a survey.
Right.
And it's really in your best interest, Mr. Seller or Mrs. Seller, to provide the survey. Because if you don't, well, the buyer's going to order one themselves, their lender's going to require it, and the new technology that surveyors use, and you know, our average price for a survey is $350. The company we work with, you know, they run in, they run out, they do it quickly, and you get a lot of 1-inch encroachments into
right.
utility easements, drainage easements, setbacks, things like that. 1-inch encroachments, a lot of them. Well, to get a variance from the county, the filing fee is $1,000.
Right.
So you'll get the variance if it's 1 inch. But applying for it, paying a lawyer to do it, paying the $1,000
Right.
because you didn't want to go looking for it, is really, you know, counter-effective. So, you know, if you as the agent, I mean, I know you tell your sellers that this is important, this could save your deal from blowing up.
Exactly.
And I've had a few of those. This can save you a $1,000 filing fee and a delay in closing. And if you have back-to-back closings, that delay can be crucial. They might need the money from this sale to buy the next property. So that's misunderstood, you know, just as much as the seller's disclosure. It's really in the seller's best interest to give it. It helps the deal go smoother. It makes the buyer feel, wow, the seller's being cooperative. What a nice person.
right.
They saved me $350. And it makes it possible to compromise on other inspection issues that might pop up. Both sides win.
Well, Don, I appreciate you coming on the show. I know we didn't
Thank
get
you.
to cover everything in the time period we have here, but I'm sure we'll come back next month,
Sure.
and maybe we could continue this on the most common mistakes buyers make
Thank
when
you.
purchasing property. Thank you, Don.
Thank you for having me.
Thank you.